On behalf of Womble Bond Dickinson, welcome to our webinar on Families First, Coronavirus Response Act, or the Families First Act. I'm Beth Jones, a partner and leader of our labor and employment team, and the focus of our presentation today will be on the emergency FMLA expansion, a temporary expansion of job protection benefits under the FMLA. The first-time paid leave has been offered by the federal government under the FMLA, and the emergency paid sick leave, also created under the Families First Act. In addition, we'll discuss the payroll tax relief or tax credits provided under the Act. This will be the focus of our webinar today, although there are numerous acts under the Families First Act designed to alleviate the adverse economic effects of COVID-19 here in the United States. Thanks for joining us today. As we begin, let's go over a few logistics for today's presentation. First, the slides and recording will be circulated to everyone after the presentation. You can submit your questions through the Q&A box on the side, and we'll try to address those at the end of the presentation, but we will circulate an FAQ sheet afterwards when we distribute the slides and recording. Also note that some of the presenters, as many of you, may be working from a remote from home environment. Please be patient. If at any point a presenter has technical difficulties, we'd ask that you hang on the line and don't disconnect, and we'll endeavor to rejoin promptly. Today's agenda will be focused on the paid leaves and tax credits. Truly, you have very little time to comply with the Act, less than 2 weeks. We're going to cover the key aspects, address some frequently asked questions, and then hopefully, if time permits, your questions. It's my pleasure to introduce you to my partners joining me here today. Andy Coburn, an experienced transactional partner with deep understanding and experience in employee benefits and executive compensation. Andy's resident in our Greenville, South Carolina office, and will talk to us about the tax credits provided under the Act. And John Puchel, a labor and employment partner from our Winston-Salem office, who represents employers in a variety of employment law matters, from litigation to compliance, will talk to us about the coverage of those covered by the leave, how we calculate pay under the leave, both under the emergency FMLA and emergency paid sick leave. COVID-19 was declared a pandemic on March the 11th. Inevitably, it will spread across the world. It's on the minds of almost everyone. It's simply an unprecedented situation. It's highly disruptive to our work, our school, our personal lives, our health and safety. Employees are under significant stress. All indications are it will be getting worse before it gets better. As we look at the reporting of COVID-19 across the U.S., the challenges mount for business continuity and staffing. The pandemic is affecting hundreds of thousands of people directly and rapidly taking a toll on the global economy. And governments face the need to control the widespread community contagion. Seeing the extraordinary measures and lockdowns on people and movement, the public health best practices are beginning to yield results, but it continues to move fast. And how are employers and businesses responding? We continue to see increasing stay-at-home orders and shelter-in-place and lockdown orders become possible, emergency proclamations, travel restrictions have been put in place throughout the world, causing the need for social distancing with everyone remaining grounded. It's an increasing strain on the healthcare system. Recently, we see an increased number of requirements for temperature taking, respiratory checks for guests and visitors. And it's in this context that Congress passed the Families First Act. This emergency relief is to be put into place no later than April the 2nd. It's temporary paid leave, both the paid sick leave and the extension of paid FMLA sunset at the end of calendar year 2020. No doubt these are extraordinary times. The paid sick leave and paid FMLA mark the first time the federal government has established employee paid leave, initiatives that previously have not been successful. We also know that regulations are forthcoming, but given the planning necessary to implement these leaves and personnel planning, it seems advisable to familiarize ourselves with the Act itself. With that, I'll ask John to take us through the Act and the leaves provided.
So good afternoon, everyone. I'm John Pichelle. Great to talk with you today as we try to figure out how this law that we're all hastening to read and understand applies. So I think we should start at the beginning with some foundational questions, and that's who's covered. And when we talk about coverage, we're talking about two separate and important things. First, what employers does the Act apply to? And then second, what employees of those employers does the Act apply to? So as to covered employers, the scope of the Act is sweeping, as no doubt all of you on this call have seen. Government employers are covered as public agencies, and all private employers with less than 500 employees are covered. So that includes private businesses across all sectors. It includes nonprofits, small businesses, family business, and larger organizations up to 500 employees. We've been asked a lot, why less than 500? Why not the big companies? And I try to avoid thinking about what's in the mind of any government official these days, but the right answer, I think, at this time is we're not sure. It could be that the first need was to get relief to workers of small businesses who were thought to be most likely to be impacted first, and I think that's proven to be the case as we work with some smaller businesses that have really felt the immediate impact of shelter-in-place orders or even voluntary social distancing, restaurants in particular and their servers. And so it may be that this was the first phase of relief, and maybe Congress is going to get around to addressing maybe other forms of relief for employees of larger organizations. But as of today, we are where we are, and this law applies to employers with less than 500 employees. So just to address for a second, really small businesses, and we're going to talk about employers of less than 50 employees. I know our HR professionals on the call are probably familiar that with respect to most federal employment laws, small businesses are often excluded from coverage. For example, the Family and Medical Leave Act, the FMLA that's been amended and we'll be talking about here, it generally applies to employers with more than 50 employees. Title VII, the main federal anti-discrimination statute, it applies to employers with 15 or more employees. But that's not the case here with this Response Act. It applies to all employers if they have less than 500 employees. For you real small businesses, for the less than 50 employees, I do want to make this note because it probably bears attention. The Department of Labor may issue regulations to exempt small businesses with fewer than 50 employees. if the obligations under the Act, the paid leave that we're going to be talking about, would jeopardize the viability of the business as a going concern. As of a couple of hours ago, maybe I need to check while we're on this, the Department of Labor has not issued any such regulations, and we will see if they are issued before the April 2nd effective date of this law. But I know a lot of small businesses right now are doing the math on this. You know, can they afford to provide this leave and then hopefully be able to get the credits in a timely manner, as I'm sure Andy will cover after we speak here. So that's the covered employers. So basically everybody less than 500 employees and government employers. So now let's talk about the eligible employees. And again, the Act is sweeping in its coverage as to the employees are covered. And so the definition of employee is based on the Fair Labor Standards Act, and that's the main wage and hour law in the U.S. And it defines who an employee is quite broadly, and it's any person employed with an employer. So it's basically anybody that's an employee. It includes everyone, whether they're full-time, whether they're part-time, whether they're seasonal, whether they are temporary. It does not include workers who are true independent contractors. And if you've been following employment law the last number of years, you will know that there's been a lot of attention to that paid by the states and the IRS as to whether folks are correctly classified as independent contractors or not. But this Act does not cover true independent contractors. As we will see with paid sick leave and the paid family medical leave that we're going to talk about here, to be eligible, the employee must be unable to work, and that includes being unable to work remotely. So if an office is closed, but probably like many of you on this call, you're at home fully dressed in your coat and tie working away, then you are not going to be eligible under the Act because you are able to work. And that's an important thing to keep in mind as we go through here. I want to talk for a second. I know we've got some healthcare clients, not clients, but healthcare businesses on the line. And I want to talk for a second just about the healthcare exemption. Businesses that employ healthcare providers may exclude them from the Act. Now, healthcare providers is defined narrowly. It's doctors and dentists and psychologists and chiropractors and nurse practitioner, nurse midwives, clinical social workers. But it doesn't include some people you might expect, like nurses, nursing assistants, pharmacy and pharmacy techs, and other direct care patient providers. And they're not included within the definition of a healthcare provider. The other thing I want to make clear is that when the Act talks about exempting healthcare providers, it's talking about employees who are healthcare providers. It does not refer to everybody that may work, for example, for a hospital. It's keyed on the particular employees. And so I know healthcare businesses are waiting anxiously for some guidance on and whether there might be any relief or expansion to pick up their nursing staffs and their CNA staffs. They're waiting guidance on that point. But as of right now, healthcare providers can be exempted from the definition of employees if they are defined healthcare providers, like we mentioned, doctors, dentists, et cetera. So the two main forms of leave, we're talking about paid sick leave and paid family medical leave. All employees, period, are eligible for the paid sick leave. For the paid family medical leave, what has happened in this Act is that it has amended the FMLA, the Family and Medical Leave Act. And those of you that are familiar with FMLA know that typically there are service requirements for employees to be able to invoke the rights or of the FMLA. Typically, you've got to be there for a year and you had to have worked 1,250 hours in the prior year. So when it comes to the paid family medical leave under this new act, all of that is gone, and the only requirement now for the paid family medical leave is that the employee must have been employed for 30 days. All of the other service requirements, with respect to this leave, it doesn't wholesale eliminate it for all other forms of traditional FMLA, but for this leave, all of those service requirements have been replaced with just being employed for 30 days. All right, so the first bank of leave is the emergency paid sick leave. And so let's talk about that. Again, all employees are eligible for the emergency paid sick leave, and that's regardless of length of service. Full-time employees are eligible for up to 80 hours, 2 weeks of paid sick leave. And part-time employees are eligible for a number of hours equal to the number of hours they work on average over a 2-week period. So for example, employees that might have a work week that's, 30 hours one week and 20 the next, you'd be on average at 25 if my math is correct. And if it's not, forgive me, I have an English degree. So the other important aspect of emergency paid sick leave is that it's for very specific reasons. And so the employers are entitled to use the leave usage under the emergency paid sick leave portion of the Act for basically COVID-19 related reasons. So again, the employee has to be unable to work, and that includes unable to telework or work remotely. And the qualifying reasons to get emergency paid sick leave you see on the screen in front of you. And that's the employee has symptoms related to COVID-19 and is seeking medical care. The employee is self-quarantined based upon a doctor or provider's recommendation. And we've gotten a lot of questions on this particular point already. What if someone is self-quarantining because they believe they have been exposed? For example, perhaps they've received notice from their employer that a coworker that they have been in contact with is exposed, but they've not been to see their doctor yet. Does that count as self-quarantine? And probably as with a few other things today, we don't have a good answer to that. I suspect that if most people call their doctors today and say, hey, my employer told me that I was working in the same cubicle with someone that's been diagnosed with COVID-19, I suspect the recommendation from that provider would be to self-quarantine. So I think this is one where we'll want to get more information from the employee. If they say, I am self-quarantining, and you ask, have you been to see a doctor? And the answer is no. I think that's one where you're going to want to hear all of the facts before you make a decision. And I don't have clear guidance for that on you today, for you on that point today. Employee is quarantined or isolated by an order from a federal, state, or local authority. That seems pretty clear, right? The one question that there is not clear is, do shelter-in-place directives count? So, for example, the state has not quarantined you or not ordered the person to be isolated, but rather it's a shelter-in-place, or they're recommending you to exercise social distancing. Does that count as an order from a federal, state, or local authority? If you read the statute, that is not clear. The statute says quarantine or isolated, and to read the CDC and other health officials, that's different from a shelter-in-place order. And so it's unclear, but I can tell you that a lot of people are presuming that a shelter-in-place order applies. But the statute, at least as of today, and hopefully, or perhaps there'll be some guidance in the regs, that's not clear. Employees caring for a family member or individual who's quarantined due to COVID-19. So obviously that would be a qualifying event. And this is very common in more and more places now. The employee has to care for a child whose school or daycare provider is closed due to COVID-19. And that is true in many places, including where I am calling from here in Winston-Salem, North Carolina. So the right to emergency paid sick leave ends on the next scheduled shift following the employee's return to work after taking the sick leave. What if an employee may need to use additional time for either the care of a family member for his or own eligible condition? Can you take this intermittently, in other words? That is not clear. Whether the statute says it ends when you return to work, it doesn't address what would happen if you return to work and then you have a time left, you still have paid sick time left, but then another qualifying need for leave arises. Do you get that? And again, that is not clear. So in the interim, we're going to keep our eyes out to see if there's any guidance issued on that point. For you who are employers out there, you should probably keep an eye on this point to stay up to see if any additional guidance is issued before denying an employee's request for additional leave after they return to work, and then to say that they need it again. Here's some additional points on the emergency paid sick leave. First and foremost, it doesn't carry over into 2021. This all ends December 31, 2020. So this is a short-term law. We all hope that there's no need for Congress to consider extending this into 21. Like many state paid sick leave laws, this emergency paid sick leave is not payable at separation. So if an employee leaves employment and has not had the need to request and receive paid sick leave, they don't get it paid out at the end, as it doesn't have a cash value in that way. Employers may not require employees to use other forms of paid leave prior to using the paid sick leave. So you can't say, we want you to draw down your sick bank before we get there. You can't require that. This paid sick leave is in addition to other forms of paid leave. An employee can elect to use other forms of paid leave, but cannot be compelled to do so. There are some notice requirements for emergency paid sick leave. And I'll caveat that by saying one of the challenges right now in the early weeks of this virus situation is that a lot of times paperwork is going out the window. Companies are trying to scramble to stay afloat, and their normal adherence to documenting things in the way that they normally would have been challenged, to say the least. But for folks that are in a position that want to or are practically able to, you can require folks to follow your call-in procedures after the first day of work of paid leave if you want them to do. I imagine some employers have no desire to do that. I'm sure that other employers practically may not be in a position to do that, but you can do that if you want to. In addition, it wouldn't be a federal law if there wasn't a required posting, and so there will be published a model posting by the Department of Labor that will go with all of your other normal postings about employment law, workers' comp, and OSHA, et cetera. So a notice is coming that must be posted. So be watching for that. Supposedly it's going to come out in a couple of days, but we will see, because with the regulations and the other things DO has to do, they are going to be pretty busy. So now let's talk for a minute about the emergency paid family medical leave. And this is the amendment to the Family and Medical Leave Act, the FMLA. So what does it provide? It provides for 12 weeks of job protected leave. The first 10 days of that are unpaid, and the remaining days, up to 12 weeks, are paid. And we'll talk about in just a moment how you calculate the pay for that. There is only one reason that you're allowed to invoke the emergency paid family medical leave, and that is to care for a child under the age of 18 due to the closure of a school or child care provider due to a COVID-19 emergency. So the leave benefits under this are longer, but there's only this one qualifying reason. As I mentioned, the first 10 days are unpaid. They can use the emergency paid sick leave Act requirement of 2 weeks pay during that 2-week period. In addition, an employee may elect to substitute any paid time off for the unpaid portion for that first 10 days. They can use PTO, vacation, or whatever else it might be provided for under your policies, but an employer cannot require the employee to use that time for the paid family medical leave. And that's different than the regular FMLA. I'll talk in a moment about the pay and how that works. But the other thing that's important to know is that this has a reinstatement obligation attached to it. So employees have to be reinstated to the same or equivalent position if they're able to return to work at the end of 12 weeks. And that's very similar to those of you that are familiar with the FMLA. It also has the reinstatement obligation, such that people can take the leave that they are entitled to and then be returned to the same or equivalent position. They can't be moved out to another position or a lesser paying position or a different one. They have a right to be reinstated. Some of you may be thinking, if you are with a smaller organization, that this might be very problematic if you are at a very small company and you've got to have workers and you can't have somebody out for 12 weeks. And so reinstatement is not going to be required under certain circumstances for employers with less than 25 employees if this crisis, and I'm talking about the COVID-19 crisis, causes the employee's job to be eliminated. So for example, you have 20 employees and someone goes out and you must replace them, or rather you've got to eliminate some positions. Then you are not required to reinstate. However, you notice in that bullet point, under certain circumstances, that's that's lawyerese, for there's other things to think about. The reinstatement obligation will last for 12 months, so even for small employers. So for example, and we all hope this situation passes quickly, if in 10 months you're able to rehire people, then you would have an obligation to reinstate that person if they were still available. So keep in mind that as this goes by, if you've eliminated positions and you're a smaller employer. So now let's talk about calculating the correct pay rates. And this is it's complicated and it's not complicated. So the numbers you see on the screen there, that's not complicated. We can all follow the numbers. The application may be a little bit more difficult, and figuring out what the right regular rate to be used can be complicated. But let's just start with the basic requirements. So for the paid sick leave for an employee who is sick and needs to take care of themselves, that employee is entitled to the regular rate of pay based upon their normal schedule or minimum wage, whichever is more. Compensation is capped at $511 per day or $510. However, companies can certainly go beyond that if they wish to. paid sick leave because you're taking care of a family member or a child or, due to a closure, that's 2/3 of the regular rate of pay for normally scheduled hours. You see capped at $200 per day or $2,000. FMLA is slightly different. If you are entitled to paid FMLA, again, remember the first 10 days are generally unpaid. But after the first 10 days, the remaining time off up to the 12-week maximum of FMLA leave must be paid at 2/3 of the employee's regular rate using the same hours and rate of pay calculations that are above. So what is the regular rate? For folks that are, well, let's say it this way. An employee's regular rate is the hourly rate an employee is paid for all non-overtime hours worked in a work week. The tricky part of it is, and there's no different guidance in this new law, so we're looking to basically the Fair Labor Standards Act principles on this point. So under the Fair Labor Standards Act, when you calculate the regular rate, you include all compensation received by the employee in a work week. So that would include wages, bonuses, commissions, and other forms of compensation. So it may not just be for an hourly worker, let's say they make, $15 an hour, but in addition, they get, for example, a commission or a production bonus. That will be included in the regular rate of pay as well. For those of you that are HR professionals and are used to calculating overtime pay, that can be tricky to calculate. So there's nothing in here that makes this regular rate of pay different than what is calculated under the Fair Labor Standards Act. So that's an important point to be aware of and be mindful of as we all sort through this. Enforcement of remedies, I just want to talk for a minute before I turn this back over to Beth. As you might expect with any laws, or any employment laws, there can't be retaliation for invoking or exercising your rights to it. So you can't fire employees for taking a leave or for filing a complaint or any of those other things. This is enforced under the Fair Labor Standards Act kind of rubric, and so the fines can be significant. The interesting thing is that there may not be a private right of action for the Emergency Medical Leave Act portion. So as you guys probably all know, employees can sue directly for violations of the FMLA. You may not be able to for any employee that brings a claim under the Emergency Medical Leave Act portion of this act. The last thing I will note is that you will see in the orange box in the top right corner that there is some good news on this point. I can tell you all I have been doing essentially is reading this law since it came out, and there, you can see that there's still a lot of things that have yet to be figured out or firmed up. And so the Department of Labor has issued a press release saying, for the first 30 days of this law, we're going to have a non-enforcement policy. And if you are trying in good faith to do your best to figure out this law and comply with it, the Department of Labor is saying we're not going to penalize you for that. Instead, they want to work with companies to answer their questions and to help them come into compliance over the next 30 days. Beth, do you want to handle some of the burning questions you have been getting lately?
Yes, John. Thanks so much for that overview. Let's tackle a few FAQs that may be on your mind. First, let's talk about how do we count employees? How do we measure them? Does the 500 employee coverage limit apply to employees throughout the entire company or only measured at a single location? under this expansion of FMLA, we count company-wide. We count employees at all sites of the company, not by location. Those of you familiar with FMLA recall the requirement, an additional requirement for our standard or regular FMLA, that there be 50 or more employees within a 75-mile radius for FMLA to apply for employees at that site to be eligible for FMLA. That does not apply in this expanded FMLA situation. How about if we have interrelated companies? Will they be considered each a separate employer under the Families First Act, or will they be one employer? Usually, they'll be considered separate employers. Generally speaking, separate companies will be treated as separate employers. The answer will depend, though, on a variety of factors about how interrelated they are. Do they have common management? Do they share labor management? The hiring and firing decisions, how interrelated are their operations? It's possible that they could be combined in certain circumstances. It's measured like it would be under the FLSA. What if my company has over 500 employees? Employers with over 500 employees do not have an obligation to provide the paid sick leave or the paid FMLA. Public employers actually are covered if they have one or more employees. So to be clear, public employers, the standard is different. Whether they have one or more employees, they are covered. And the question that we have received is, are community colleges in North Carolina covered? And yes, we believe community colleges in North Carolina would fit in this public or governmental employer category and be subject to the Act. Nonprofit companies are also subject to the Act, nonprofit employers. Do I have to pay this leave if I decide to close the business temporarily and employees are unable to work? If the business is closed or shifts canceled due to lack of work, paid leave would not have to be paid under the Act. You'll remember John talked about specific COVID-related reasons, both for the paid emergency sick leave and for the paid FMLA. Lack of work was not a qualifying reason. So if you do have to pay sick leave, what if an employee has a varying work schedule? How do you calculate the number of hours of paid leave for the employees? For part-time employees, you use the number of hours that they work on average over a 2-week period to calculate the paid sick leave. Remember, full-time employees are entitled to 80 hours of paid leave. But part-time employees, you would figure out their average over a 2-week period. Can we require employees who want to take this paid sick leave to find coverage for their shift before they take it? No, we can't require that. This is not an accommodation, but a mandated leave that if the employee is eligible for it, must be provided by the employer. There can't be any retaliation or interference with that in them taking their qualified leave. Can employees use the paid leave under the FMLA policy, the paid sick leave? Yes. As John mentioned, employees can elect to use the available paid sick leave in place of the unpaid first 10 days of the expanded FMLA leave. This is a choice for employees, however, and they can use the emergency paid sick leave, or they could use any other accrued paid leave that might be applicable to the leave that they have. This is the employee's choice. Now let's turn and have Andy talk to us about tax credits. We've heard that there's some tax credits under the Act, and Andy will explain to us how these tax credits work for the leaves that we are have been discussing, both FMLA and paid sick. Andy?
All right, good afternoon. Let's jump right into it. The tax credit is a credit against federal employment taxes. Because not everyone hopefully spends their lives in the midst of payroll taxes, let's quickly survey the field so we understand what we're talking about. Federal employment taxes have a number of different components. As you see on the screen, there's an employer-paid portion and an employee-paid portion. Employer-paid Social Security and Medicare taxes, and then there's a withholding from employee pay also for Social Security and Medicare taxes. There's obviously also income tax withholding, and then the additional Medicare tax for employees with very high incomes. Need to be clear that the credit is only a credit against the employer-paid portion of Social Security taxes, the 6.2% that's paid by the employer. And in connection with that, I want to note that there was an IRS release on March 20th, which talked about applying the credit against basically all forms of employment taxes. That's not consistent with the statute. Obviously, Congress is working hard on additional relief. That additional relief does include the possibility of other payroll tax relief, but that has not been enacted yet. So as we sit here today, we're just talking about a credit against employer-paid portion of Social Security taxes. So what does it cover? The tax credits are designed to cover mandated paid leave, either the paid sick leave or the new paid FMLA leave, no more and no less. The credit is equal to 100% of the cost of the mandated leave payments that you make. It's applied first against the employer-paid Social Security taxes, as I said. The good news is that if the cost of the mandatory sick leave exceeds the amount of the taxes you're paying, you get a full refund of any excess amount. So one way or another, you are going to get covered for the entire cost of the mandated leave under the Act. But do keep in mind that the tax credit is only available for paid sick leave that is mandated under the Act. If you're over 500 employers, over 500 employees, and you choose to provide paid sick leave, the credit is not available. If you're under 500 employees and you want to be more generous than what's required by the law, you can do that, but there won't be any tax credit available for any excess amounts that you elect to pay. The tax credit is also increased by an amount intended to cover continued employer costs for health care coverage related to the mandatory sick leave. We need to wait the new regulations that are going to be issued for the details of this, but the concept is if my employee's out and is receiving the paid sick leave, for example, for a period of time, if I continue to provide health care coverage for that period of time, my employer portion of the health care costs under my group health plan for that employee will also be, that amount will also be a tax credit. The exact same tax credit, just increases the amount. It's applied against Social Security taxes paid by the employer. If there's an excess, I'll get a refund. The tax credit applies on a quarterly basis. We'll come back to that when we get into some of the FAQs. There's a critical issue about timing and when am I actually going to get the benefit of this credit. I'm going to pay out the wages. When do I get the credit to offset that? Am I going to be sitting there waiting for payment? We'll talk about that. Another general principle you need to be aware of is the credit is designed generally so that you can't double up on tax benefits. So the employer's income is actually, taxable income is actually increased by the amount of the credit. And the net effect of that is you'll get the credit, but you won't also get a tax deduction for the same amount. You also can't double up with other types of credits. And most notably, there's an existing tax credit that came in the fairly recent tax legislation for certain employers who voluntarily adopted paid leave policies. You can't use the same wages to qualify for that credit and to qualify for this credit. Also, there are existing reductions in Social Security payments for certain credits, for payroll tax credits for qualified veterans and for research costs of qualified small businesses. Again, you can't double dip. You can't use the same, you can't apply, get that credit and this new credit against the same wages. All right, and let's hit a couple of key issues that have been coming up. The first one goes back to the fact that this credit is supposed to apply on a quarterly basis. And the critical issue so many employers have already been talking to us about is, wait a moment, my payroll tax deposits are during the quarter. Am I going to have to wait all the way until the end of the quarter to get the benefit of this credit? The good news is the answer, well, there's partial good news we know about, and then the other half of it has to be, we're going to have to wait and see. The details have yet to be worked out on how you're going to make the estimate. But the intent with the offset to your Social Security, your employer-paid Social Security taxes, is that you'll estimate the credit for the quarter as you go, and you will be reducing your Social Security payments as you make them. So you won't be paying those taxes and then asking the government for money back later. You're just going to be reducing it as you go. Now, because you'll be doing this during the quarter based on estimates, obviously there will have to be a reconciliation at the end of each quarter, positive or negative, if there's any discrepancy between the estimate and the actual facts. We do not have any guidance yet indicating how quickly refunds will be paid if your credit amount exceeds your Social Security taxes. All I can say, the small hope I can offer you at this point is that it's very clear from statements made by the government agencies that they are well aware that this is a critical issue for businesses. If they have to pay out the paid sick leave and then they have to wait till the end of the quarter for a refund, that could be disastrous, particularly for small businesses. We don't know. We'll have to wait and see. The next step will be they'll probably tell us when they hope to get us refunds, and then we'll have to see what the IRS can actually pull off in the real world. Another question, are mandatory leave payments subject to employment taxes? They are exempt from the employer portion of Social Security taxes. So the same 6.2% against which you take the credit, that tax does not apply to your mandatory leave payments. The payments are subject, however, to all other federal employment taxes. For anyone who's not a payroll person, you can close your ears for the next 30 seconds, but for you folks who deal with payroll out there, note that there's a somewhat odd provision dealing with Medicare taxes, and here's the brief skinny on it. Again, if you don't deal with payroll, just ignore this. What you actually get is for Medicare taxes, and we're talking again only the employer portion, so the 1.45% paid by the employer on the employer-paid Medicare taxes, you will actually get a credit for that amount for those taxes that are paid on the mandatory sick leave payments. You'll get a credit, but that credit is part of your credit against employer-paid Social Security taxes. So they're not just flat out exempting it from those taxes. They are giving you credit for it, but it's going to go over into the Social Security bucket rather than the Medicare tax bucket. So you're still going to have to pay that Medicare tax, but then you're going to have an offsetting increase to the tax credit against the Social Security taxes you pay. And again, if there's an excess, you will get it back in a refund. So at the end of the day, you will get covered on the Medicare, employer-paid Medicare taxes on mandatory leave payments. The government will pick up the tab for that, but the mechanics are a little bit more complicated. And finally, there are important details yet to be worked out. The agencies are supposed to issue regulations and additional guidance within the next 15 days. Obviously, hopefully that will come out sooner rather than later. I think on the tax credit, the most important question is going to be the real-world operational issue of how fast will the IRS be able to process refunds. That takes care of tax credits. Beth, I'm going to pass it back to you.
Thanks, Andy, for that explanation about tax credits. Let me ask you a question about those. It sounds to me like we're going to need to keep track of each type of leave separately, potentially, to properly be able to claim the credit. Do you have any tips for folks about the types of things they need to be keeping track of, or should they be talking if they do their payroll themselves to their accountant? How should they keep track of all this? It seems like a paperwork nightmare.
Well, unfortunately, that's largely in the to be determined column. That's one of the issues that's supposed to be covered by the additional regulations and guidance that's coming out. Certainly, it's not too early to think about what you can do and what's the easiest way that you could document in your payroll systems and or otherwise, so that if you're asked later by the IRS to document how you figured out the tax credit and why this person was eligible for it and why that one was not, you'll have a paper trail, but that is largely an unknown, Beth, at this point. We're really waiting on the guidance for that.
Thanks, Andy. And John, I'm going to ask you a question that I think might have a similar answer. How do you calculate the dollar amount of leave when an employee is paid with commissions?
I think that is also going to be in the to be determined category. The law doesn't specify any kind of look back period, like what the person's average comp was in the past, 6 months or 12 months, like it does for part-time employees. So the law references back to Section 70 of the Fair Labor Standards Act, and that just says the employee's regular rate is all these wages, and it doesn't include certain things, but it doesn't specify how to determine that in a particular week for the purposes of this new law. So that's one of the things we will hopefully get some guidance on, because it's just not clear.
Okay, we will be looking for those regs, because it sounds like we're relying on those to answer a number of questions. Of course, Congress enacted this on a compressed time frame, so there's likely to be a number of things addressed in the regs, although the regs are going to be developed in a compressed time frame, so we may be left on our own on some of these. Another question, John, what if an employee, perhaps they're a part-time employee, is not eligible for paid leave at an employer right now? They don't get that as a benefit. Are they still eligible for this paid leave if they meet all the other requirements?
Yes.
So the employee does not have to be benefits eligible at currently to be able to take this paid leave.
That's right.
Okay.
If you just have to be employed and have a qualifying reason for the paid medical leave and for the paid family medical leave. You just have to be an employee that has been there for 30 days.
All right, thank you. Hardship waivers, form notices, all of these things, we hope the regulations will give us a roadmap, hopefully provide us with a sample. But at this point, we don't have any details on what process a small company could apply for a hardship waiver for, how they would do that. We just don't have that information at this time. Thank you for your questions today and for attending the webinar. Our time is almost up. We have circulated the slides. The recording will be circulated to everyone in attendance. And we'll also compile the questions that we received with brief answers and distribute those as well. We appreciate your participation today. And we wish you good luck in administering this and hope you found this helpful as you begin to plan for and implement these paid leaves. Thanks very much.